It took mere hours after the Supreme Court handed down its bombshell ruling granting Trump partial immunity for criminal acts committed in office for him to seek to overturn his Manhattan conviction, citing this exact Supreme Court decision. Donald Trump is now seeking to throw out his conviction and postpone his sentencing, which is coming up on July 11th, citing now that the immunity granted to him by the Supreme Court absolves him of culpability for the 34 felony counts on which he was convicted. In terms of whether this gamble is going to work, it's anyone's guess. On one hand, the Manhattan case focuses on acts that Trump took as a candidate. He was literally running to become president and falsified business records to hide an affair he had with Stormy Daniels to help himself in the upcoming election. So this Supreme Court ruling shouldn't apply. But on the other hand, Trump's team will argue that prosecutors built their case using evidence from Trump's time in the White House, like, for example, checks that he signed while he was president. But under this new Supreme Court ruling, prosecutors aren't allowed to cite evidence involving official acts, meaning if any evidence had even a tangential relationship to Trump's official position in office, then it can't be used, even if the crime at hand has nothing to do with official acts. So there is a world in which Trump's defense attorneys could convince a certain kind of judge to side with them. And after this week, I'm sure it's not exactly a stretch to trust me when I say that there are plenty of judges like that, and that Trump's team has a way of ending up in their courtrooms. Granted, there is yet another wrinkle for Trump. The deadline for filing post-trial motions was last month, meaning it may be too late to even raise this issue. It may have to be held until such time as Trump appeals whatever his sentence is. With that said, the Manhattan DA was expected to make a sentencing recommendation to Judge Merchan on Monday about whether to imprison Trump or not, and yet they failed to make that motion. Whether that has something to do with the Supreme Court ruling remains to be seen, but it's worth noting that that was expected to be submitted. All of which is to say, everything is very much up in the air, very much in flux, and very much at the mercy of what a number of judges, prosecutors, and lawyers ultimately decide to do. Here's my legal breakdown co-host Glenn Kirshner attempting to make sense of this very fluid situation that we're finding ourselves in. What happens to Donald Trump's other prosecutions that he's contending with? For example, in D.C., a lot of the evidence in D.C. and in the Florida case, for example, a lot of the evidence is Trump's own records, for example, or testimony from those closest to Donald Trump. If this is the precedent that's established now, how is any of that going to be admissible in this case, and what will happen to these cases that Trump is facing?
Brian, that's the great next question, and I am a little sick to my stomach right now because what the Supreme Court has done is like making up a new rule of evidence that wasn't even in existence. For example, when Donald Trump was being tried in New York for his 34 felony crimes, all of which he was convicted of, because when they come up with this new rule out of thin air saying testimony or records from the president or his advisors may not be admitted at trial, there were potentially some things admitted into trial that Donald Trump said or did when the prosecutors in New York were proving those 34 counts of falsifying business records to cover up hush money payments because Donald Trump wanted to steal the 2016 presidential election.
If he were to appeal that, based on this new Supreme Court ruling, how does that work in terms of, like, does Donald Trump's New York conviction stand because this Supreme Court precedent wasn't established when the conviction was handed down? How does that work?
So I fear that it works in the following way. When the Supreme Court announces a new constitutional principle, we have this fiction that says the Constitution always meant that thing. We just didn't know it because the Supreme Court hadn't had occasion to rule on it. So it has what we call retroactive application, which means it could very well be that as part of Donald Trump's appeal, he says, well, look, the Constitution says a bunch of this evidence that the prosecution admitted against me in my New York case was not admissible, and the Supreme Court just said so. Unfortunately, they said so after his New York trial. So I can tell you, Brian, there will be robust litigation on this. And here is what I fear to my core. It's not necessarily going to be robust litigation that awaits Donald Trump's appeal after he's sentenced on July 11th. It may mean his July 11th sentencing gets pushed off. Again, it is, horror show after horror show after horror show. And similarly, down in Georgia, for example, if there's any good news, now that there is this new constitutional principle about what evidence can and can't be used against a president, former president, who's being criminally prosecuted, at least they can work it into litigation in advance of the Georgia trial, because we're treading justice water down in Georgia as well, while Donald Trump and some of his co-conspirators, his co-defendants, his criminal associates appeal Judge McAfee's ruling on whether District Attorney Willis, was properly allowed to continue to prosecute this case.
All of which is to say, things are very much up in the air, all thanks to a Supreme Court whose job is to interpret the Constitution as written, and yet which instead decided to invent out of whole cloth entirely new provisions of what the Constitution actually says. I mean, think about this for a moment. These people parade themselves around as textualists and originalists, and yet they decided that a constitution that said quite literally nothing about presidential immunity for criminal activity somehow existed. To be clear, it doesn't. In fact, the Constitution does offer civil immunity for legislators through what's called speech and debate. So the fact that the framers put that in the Constitution and yet chose not to put anything about criminal immunity for presidents shows us by negative inference that the decision to do so was deliberate. This Supreme Court then overturned 200 plus years of precedent. And yet, on the opposite side of the coin, consider Section 3 of the 14th Amendment. There, the plain text of the Constitution says that no office holder who, having previously taken an oath to support the Constitution, shall have engaged in insurrection against the same. Doesn't get clearer than that. And yet somehow, that was too ambiguous for this Supreme Court. They will ignore the obvious words in blind deference to their God King while creating out of whole cloth new provisions to shield him. They do not serve the Constitution, they serve Donald Trump, and they should 100% be impeached and removed for their inability to faithfully execute their duties in office. And that's a point that my Democracy Watch co-host Mark Elias laid out.
Yeah, originalism and textualism has been replaced by vibism. Right? This is just like conservative vibes. They're just like vibing that Donald Trump shouldn't be kicked off the ballot, and they're vibing that Donald Trump should have immunity. But the fact is, they are both similar cases in that in one instance, textualism and originalism would have kicked Donald Trump off the ballot, and in another case, it would not have given immunity to presidents. Right. As you point out, there is in the U.S. Constitution a clear provision of immunity to members of the legislative branch. It's called speech and debate immunity. There is not immunity anywhere to be found in the Constitution for the President of the United States. And they created an immunity that is not just what Donald Trump wanted, but Donald Trump wanted and then some. They gave him more in some senses that they wanted, and they have put in serious jeopardy not just the case in Washington, D.C. on January 6th, the Georgia case about January 6th. Lord knows in Florida, he doesn't even need immunity. There he's just got...
To the point of Florida, Clarence Thomas, apropos of nothing, slipped in this little clause that I'm going to read to you right now. He said, in this case, the Attorney General purported to appoint a private citizen as special counsel to prosecute a former president on behalf of the United States, but I am not sure that any office for the special counsel has been established by law as the Constitution requires. So that's just a little nugget for Judge Cannon, who is right now litigating and adjudicating this issue of whether or not a special counsel can even prosecute this case, as she's deciding whether or not to dismiss it. And Clarence Thomas offered a little nugget to say, hey, Judge Cannon, if you dismiss this and it makes its way up to the Supreme Court, you got at least one vote in your corner.
Oh, at least. I mean, come on. He's got more than one. He's got more than one vote in his corner. I think we all know. But absolutely. And so, this will have a cascading effect with regarding a number of the Donald Trump cases. And when you take it in conjunction with the Fisher case, the January 6th insurrection case, people say, well, this is only immunity for Donald Trump, but not the people who he'd ordered to do it. Of course, he has the pardon power, and he has been clear that he will use the pardon power to achieve a political end, and he can't be prosecuted for that, we now know.
Right.
And so what is being created is through all of these decisions is a culture that the MAGA movement is going to see and is going to experience, that they can be lawless, they can be brazen, and they will get away with it. And, 4 months from the next election and 4.5 months from the next set of litigation that Donald Trump will bring to try to overturn the election, and 5 or 6 months away from the next January 6th, we should all be worried about that.
So look, it remains to be seen what happens in New York, but hopefully Judge Merchan will not allow himself to get rolled by Donald Trump in the same way that the rest of the justice system is getting rolled by Donald Trump. The only way our democracy survives is if the people with the power to hold him to account actually exercise that power. Not to put too much pressure on Judge Merchan, but what he does on July 11th will speak volumes. Not just in terms of holding Trump to account for the crimes that he committed in New York, but also in terms of showing us more broadly that while he might own these far-right hacks on the Supreme Court, that the rule of law still exists in other courtrooms in this country. Americans' confidence in the rule of law may very well falter if Judge Merchan doesn't live up to his duty to hold this remorseless, dangerous criminal to account just over a week from now. I've got a really exciting announcement. I've written a book. It's called Shameless. This book explores how Republicans have exploited their historical branding while attacking our democracy, how the media has proven itself a willful participant, and how Democrats can learn from this to rebalance the political scales and save our democracy. It has been a lifelong dream of mine to write my own book, and so I'd like to ask you to pre-order it by clicking the link right here on the screen. And if you buy within this pre-order period, your book is going to come with a signed nameplate. As you know, I've never had a single sponsor on my channel. I don't ask for money or anything like that, but if you're looking for a way to support me, this is hands down the best way to do it. So again, follow the link right here on the screen, and thank you from the bottom of my heart for pre-ordering Shameless. And as always, make sure to subscribe to see more of my content.